So let's start from the beginning. How did we even get here? So the basic of before a tax deed is this. Everybody that owns a house has to pay their taxes. They get the bill starting in November, and you get a good discount if you pay in November, or you can wait all the way until April and there's really no discount. But every homeowner has to pay their taxes. If they don't pay their taxes by May of the following year, they can get put on this list. And the list is what you call they're trying to bid on the taxes. So we got here because somebody didn't pay the taxes, the owner didn't pay, and they still haven't paid, and now they're on a list. And one of you, the investors, the realtors, the whoever it is, regular people, will bid on the list, and they'll try to get the certificate. So 18% interest, or if it's in a hot area, they can get 5% interest. So it's a bid down. But if they're not paying it, they get put on this list. And so what then happens is whoever wins that certificate for that property, they're the certificate holder. They have to wait 2 years. They have to wait 2 years before then they can apply to try to get a tax deed. Okay. So it doesn't mean that they have the rights of first refusal to try to get the deed. It means they're basically in the position to push the situation forward, to start the process of having it go before an auction. So that certificate holder waits 2 years, and then they actually apply for it in the county to make it go to a tax deed auction. And so once it goes to auction, there's a whole schedule of how much the starting bid is based on taxes owed, publication costs, title searches that the county does, certified mail. There's a whole bunch of stuff. But if you win the auction for that property, you win a tax deed. And that's an actual deed to the property. Like you get title now, and you own the property as a tax deed owner. You're not a certificate holder. You're not somebody that has a lien or an interest on it. You actually own the deed to the property. So you win an actual deed. And I did a newsletter this past week that was just part 1. And I kind of talk about some things that are going to be part 2 and part 3 in here. But it's good for you to know these basics, because some people will say, well, isn't a tax certificate a tax lien? And the answer is no. A certificate is not a tax deed. They're two different things. One is trying to get interest owed on the taxes, and the other is trying to get title to the property. So if you win, and we're not going to talk about certificates because that could be like a whole 2 hours on its own. So what a tax deed actually is, and all the investors, I know you all are going to be watching this because I know so many of you are interested in this. What a tax deed is, it's new original title. It's like a clean slate to that property now. Everything else that happened before is inferior to what you have. It's not something that's a transfer of title. It's not that the prior owner is now conveying you a deed. No, they had the opportunity to pay those taxes. They had the opportunity to do whatever they did, and they didn't pay it. And now you won the tax deed at the tax auction. So it extinguishes prior ownership. So whether somebody died on the property, whether somebody lived there and then they just abandoned it, it now extinguishes whatever they had. And we'll talk about what the county's duty is. The county has a duty to notify the prior owners. They have a duty to notify the mortgagees, mortgage holders. But the idea is it extinguishes many, I mean, not all interest, but many interest on the property. So if you've never seen a tax deed before, this is what a tax deed looks like. You can pull up properties in 09, 08, 322110. You can pull properties anywhere around that area, and you'll see in the chain on the property appraiser, you'll see the tax deed. But this is actually one there when it gets recorded by the county, but it's something that we've had before in the office. So the question people ask about these is they buy these right away, and they either want to do renovations or they want to sell it right away. So they got a sweet deal at the public auction. They got a great deal. They got half the value of whatever the retail is of that property. And they now want to flip it or do an assignment. I don't do what the investors do or you all do, but you want to get a good deal on it. And the question is that an insurable title? Can you get insurable title for the buyer? And the answer is no, but there are some ways you can. Okay. So once you get the tax deed, they're not insurable title right away. So if you bring it to the title company, you get it under contract with a buyer, the title company is going to tell you, you need to either do a quiet title or you can wait 4 years. If you wait 4 years, title insurance under the statute of limitations says, well, it should be insurable. And you always check with your title company when that happens. But the quiet title is a popular topic that I've been asked about recently. Somebody will buy a tax deed in 2018. They got a sweet deal for it. And finally, a buyer now wants to come along and buy it. And they go under contract. They bring it to the title company. And then all of a sudden you find out, well, wait a second, title insurance is not going to insure title to the property. So the title company says, look, you wait the 4 years, or you hire an attorney and you do the quiet title lawsuit. We'll talk about the quiet title, but the quiet title lawsuit is trying to get clear insurable title so that once we get an order of final judgment, you can bring it to the title insurance company and then they'll insure the title. Now, the other thing I don't have in here that I learned from Don Johnson at I think we were online together. I forgot what we were doing. We were commenting back and forth, but it was on Carolyn's page. And we were talking about the other exception to the rule. If you buy a tax deed property and you live there for 1 year, you pay the taxes for that property, you live there, you can maybe claim homestead if you wanted to, but you do it openly. Everyone knows there's a way that you can wait 1 year and then have insurable title. But you better believe the title insurance company is going to want to know what you've done or what evidence you have for insuring that. So just so you know, it's not about marketable as much as it is insurable, because everybody wants to know, can we go to closing? I've had investors say, well, we'll wait the 4 years. I guess they want to do renovations or rehab or do whatever they wanted to do. So I get this question a lot, and I have the exact part, the statute of it. This is a popular question that comes in Carolyn Morales's Northeast Florida tax deed Facebook group. When you buy the tax deed, what comes off? Is everything coming off, or are some things coming off? And the statute talks about this, and it sounds all legalese, and I don't know why they make it this way, but it says that no right, interest, or other covenant shall survive the issuance of a tax deed. So most things don't survive the tax deed. Most things. There are things that still stick around. And so municipal liens, nuisance liens, demolition liens, those stick. Those things stick around because in Duval County, they have this program. But if you buy a tax deed, and I'll show you at the end, I'll show you the auction calendar, and then I'll show you the Duval County public viewer. If you find a tax deed property and the title search shows municipal liens, the county's title search, and it shows municipal liens, nuisance liens, those liens don't come off. Either you would have to pay them off, or you can do a rebate program where if you do construction or major improvements on the property, or you improve the property, they have a program where I think it's $2 you spend, you can get like $1 back. So you're almost like negotiating back the rebate. And the point of all of this, though, there's a really big point with the interest being eliminated. The county has a duty to notify lien holders, mortgagees, prior owners, existing owners, whatever it is, the last person on the tax roll. They have a duty to notify those people. And there's different ways they notify them. But in order for that to be recognized as good insurable title, unless you do the quiet title, those things have to come off. So if a mortgage company was not noticed by the county and you're wondering, okay, does the mortgage come off? Some title insurance companies, like I've heard Alliant will say, well, they weren't noticed, so I don't know if they're coming off. But then like I have another quiet title where the guy never quit claimed his interest and he was never notified of the tax deed proceedings. But then that underwriter has come back and say, well, as long as they're served in the quiet title lawsuit. So the duty of the county is something that you really need to know about. Like they have to start sending mailers, like as soon as that tax certificate holder starts the process of the tax deed of applying, now the county has to start really notifying the prior owners. So if you've ever seen one of those notices, they come and they just stick it right there on the door, wherever they want, in a conspicuous place so you see it. So tax deeds eliminate, if properly noticed by the county. They can eliminate the people that were on the prior ownership, individuals, the entity. So some of these LLCs, hedge funds, not only do they just buy the tax certificate, but they'll buy the tax deed. And so all of a sudden they've bought too many and now they can't keep up with the taxes themselves, or they have a cute strategy. I've heard about this before where they buy the tax deed. They got a sweet deal, but they don't pay the taxes. And then they wait the 2 years. Somebody else applies for the tax deed, and that auction, it goes for a lot more. So they just sat on property for 2 years and it accrued value. And so they made money just letting a tax deed go away. Weird, but LLCs are notorious for just letting some of these tax deeds go. And partnerships as well. I mean, there could be partnership people that join up and buy the deeds. And if somebody dies and they own the property and they didn't pay the taxes and now it goes to a tax deed auction and you win the tax deed, the first thing you're going to ask me is, hey, Al, do we got to do a probate? Probate? You don't. When you buy the tax deed, at that point, it's extinguishing out those rights of the estate and the people that died. Yes, in the quiet title, we would have to get what they call a guardian ad litem to represent those interests, but they extinguish out the estate parts and the guardianships. Wild deeds, this is kind of interesting. It's a little irrelevant for this presentation, but I think wild deeds is something I've seen recently. We got a case in Seminole County. Some random guy just recorded a deed and he's not even in the chain at all. There's no connection of him being in the chain. And so somebody just fails to pay the taxes and there ends up being a tax deed. Well, that's considered a wild deed, a deed that's out of the chain of title. So we've seen that before. Mortgages and security instruments, judgment liens, if they're properly noticed, they can come off. If they're properly noticed, they can come off and they do not survive the tax deed. So people ask, hey, the mortgage company's on there, have that right now. There's a mortgage on there. Does it come off? Well, we always ask title insurance, right? Everything's got to line up in a quiet title or title insurance. And title insurance is very important because if they say it's coming off and they'll insure title, good. What's the difference? If they're saying it does, fantastic. This is actually a common question. It depends where the property is though, right? So association liens, like HOA liens, there has been case law that comes out that says, yes, the tax deed did extinguish the lien. And the unpaid assessments can be extinguished. But then it gets really confusing about, maybe the HOA has future liens, like they all of a sudden have a new lien that was not something before that may still be enforceable. And there's sparse case law on this in Florida. But there has been things out there that talk about the HOA coming off. It was prior to the HO lien. It's just a common question that comes up if they're eliminated. It's almost like it depends. Terrible, but it's really what it is. I mean, case law is kind of on both sides of it. So this is a popular question. I know everybody's going to be zooming back and forth on this one. And thank you, Tim, for sharing the video. Really appreciate it. So federal tax liens. So I think it was, I can't remember when it was, but I think it was like during the middle of COVID. And I got a question from somebody and they were like, do federal tax liens come off? Do they come off? And so I think even at the session with Greg and Carolyn, when we were back at Jack's REIF, we were all like wondering, like, do they come off or do they not come off? Well, I got to a point during COVID where I said, I want to get the answer from an underwriter. I want to hear it from somebody, an attorney in the underwriting office. And that response right there on the bottom that you're reading, that was from an underwriter. That was from an aligned underwriter. So the understanding is this: if you see a tax deed and there's a federal IRS lien, if there is an IRS lien, sometimes there's not. I saw one recently where it just said IRS, but maybe there's no lien. If the IRS receives proper notice from the county, and then once the tax deed is bought, 120 days after that, then title insurance will say, yep, it comes off. Because the federal government has a redemption period. They have 120 days to now go redeem or try to get whatever they want to do. They want to pay back what's owed to make sure they have an enforceable position as their lien. But know that response, I was so happy when I got that, because that says a lot about what happens with federal tax liens. I mean, it's a lot of jumble and words and codes in there, the lawyer stuff, but it really laid it out. I mean, if they were properly noticed, if they were given 120 days from the tax deed sale, title insurance says, yeah, go for it. So I want to make sure that I'm not losing. Let's see. Want to make sure. Hold on. Give me 1 second. Hold on. All right. And the whole thing just completely went out. I have no idea why the PowerPoint just went completely kaput. So hold on. I got to back up, because unless the computer works, I'm not going to stop doing my presentation. And if everybody's watching, I can't show the PowerPoint right now, but that doesn't mean I don't have it somewhere here. And I'll start from right here. So bring this over. So what do tax deeds eliminate? The tax deeds, what do they not eliminate? So they don't eliminate municipal liens, nuisance liens, demolition liens. They don't. Easements and covenants, oil and gas, mineral rights are just not coming off. And those are just a few to name that are out there. And maybe the slideshow will be back. There we go. All right, wait. All right, we're getting there. We're getting there. First time doing this on Zoom. I have no idea why it froze, but I still got people. All right. So what do tax deeds not eliminate? Again, they don't eliminate the municipal, nuisance liens, demolition liens, easements, and covenants. So things that run with the land, maybe power line easements, utility easements, oil, gas, and mineral rights. Weird stuff like that, right? Like other things that don't come off, like with a tax deed. Pipelines, water beds, ingress, egress easements, drainage easements. I mean, things that you're probably not even thinking about, right? Like the only people that are probably thinking about that are, I don't know, title companies when they're doing the surveys. That's probably it. But these are just a couple things that are just not coming off when you purchase a tax deed. And HOA covenants, right? So the liens, the unpaid assessments may come off, maybe not future liens, weird, but the unpaid assessments may come off. The covenants, like the declaration of forming the HOA, like the paperwork, the formation doesn't go away. So when you buy that house, you're buying into the HOA. That's not like you got a house and everything around you is HOA, but you aren't. So parcel declaration, just not coming off. Public bonds rarely comes up, like public transportation, road systems. It's just not coming off. Weird things. I thought I'd share that with you. Nobody's really thinking about that when you're really buying a property. But like oil, gas, mineral rights, subsurface rights. I mean, there's different rights to different layers, and those things are not eliminated by you purchasing that tax deed. So you buy that house and you're hoping maybe to get some of the subsurface rights. They may not be eliminated. Municipal liens, and this is a hardcore statutory language about municipal nuisance liens just not coming off. That's just right there. U.S. property. Okay, so U.S. government, for some reason, fails to pay their own taxes. It's not happening. There's no way you're buying a tax deed off the U.S. government. So that their interest or owning that property are not coming off. And also weird that land that was granted by the government to the state of Florida with certain provisions doesn't come off either. But just know, like, if you think that the U.S. government's going to be out on that, you got a sweet deal. It ain't happening. Bankruptcy. So bankruptcy, this is a little different. My only thing about bankruptcy is I just say be careful. Because when I've read this and the notes I put in here, it's almost like it can be undone. So you could like buy the tax deed and then maybe the sale violated the bankruptcy order. And now the judge can say, well, wait a second, we didn't want that to all happen. And so you thought you got a sweet deal. And now, you can get your money back. And we'll talk about that. You can get the money back probably on this, probably at 12% interest plus anything else that you improved on the property. But bankruptcy, if you see the property in bankruptcy, I mean, you don't know. You don't know what the situation is. You have no idea. Is it worth it? You have to just make that decision and do the due diligence on it. So what happens? So let's just say something really random. The owner was not notified of the proceedings. Like somebody back in the chain or the one that was on the tax roll was not notified. So 2 years later, you're like, let's do the quiet title. So you do the quiet title and you notify, you serve the process server, you serve the person that wasn't served from the county. And they come back like, we weren't served. Nobody told us. Full-blown affidavit, notarized. We were never served. Files the answer. Well, it's nothing to freak out about. Again, the county is the one that needs to do the full researching. They're the ones that need to make sure. We need to notify the homeowners. We need to notify the mortgagees, the lien holders, the judgment holders. The county needs to do that. So if that person ever came back and fought and said, I want my property back, I want it now, there's a way to move forward in the suit, whether it's not in quiet title, but I guess that's the best way to do it, in a quiet title, to get a judgment that says, okay, so you can't really lose. You either get the property or you get back 12% interest from date of issuance of the tax deed. So you can get back the amount you paid in a lien back on the property. It's not like money being handed out, but you get like a lien back on the property. But you can get it back with 12% interest from the date of issuance, plus the clerk gets their fees, plus recording, plus major improvements done to the property. Let me just talk about that for a second. So one thing about tax deeds that I think is weird is somebody buys a tax deed and they immediately start doing the rehab. Well, what happens if you're almost done with the rehab? You're ready to resell it. You do the quiet title, and now you do it. You serve that person that was not noticed. Let's just go with that. And they come back, and now you've done all of that rehab. You paid all the contractors. My thoughts are, why don't you just do the quiet title first before you do the rehabs and do all of that stuff? Everybody's got a different opinion about that, but The good news is that in the statute, it talks about if that happens, if there's a tax deed sale, it's voided if that person doesn't or wants to come back, they can try, but you also have a benefit too. So just know that. And yeah, they can come back and say, we were never notified. There's defenses to it. We paid some taxes. Who knows? They can always try something. But really, one of the hardcore statutes is they were not notified of the proceedings. And if they're not notified, that's a really good defense if they file an answer in the lawsuit. I don't know if I cut out the Orange County thing. I hope I didn't, but hopefully we get there. So like I said, you can buy this tax deed thing and you can hold it for 4 years, or you can live there if you live there and pay the taxes and show that you live there. And you can wait 1 year and then hope you show that evidence to the title insurance company and they say, okay, you're good to sell it. Or you file the quiet title lawsuit. There's probably a whole seminar webinar to talk about quiet title, but all you have to know is the title insurance company cannot issue a buyer's policy until there's this lawsuit done. And the lawsuit is you go to an attorney, the attorney files a complaint, and it's to try to say you are now the owner, everybody else is out, and you're trying to say you are the owner to the property to try to get insurable title. So you are removing things off the property, mortgages, judgments, if they're there. And it's the title insurance wants it. They require it. If it hasn't been 4 years and you're trying to get a final judgment, once the quiet title's done, and they're not quick, we'll talk about that. But once you get a judgment, that is trying to say you got clear title, insurable title, marketable title. So who we have to include in quiet titles are prior owners, lien holders, existing liens, mortgages. You just have to, there's a process to it. And it's not like probate, right? Probate is you just do it, you get it done. Quiet title is you have to name people in the suit to make sure you cover your bases so that when title insurance reviews the judgment or reviews the lawsuit, they're looking at it saying, okay, well, they notified everyone. But so we have to include all these people. And if they're missing, so if they're dead, if they're incompetent or in the military, we need a guardian ad litem. And if they're missing, either on both sides, if they're missing, we still have to do like constructive service. We have to publish in the newspaper that nobody reads. So we have to publish there, and it's expensive too. They charge per inch per column. It's crazy. So quiet title, once we're done with a quiet title, we get the final judgment, title's been quieted, and people ask me this. They go, how long and how much? No, I'm not surprised. How long and how much? Quiet titles are not quick because unless it's like one person and that's it, and you serve that person, okay, yeah, maybe you're looking at a month to 2 months. But when you start looking at how many lien holders, mortgagees, certified judgments, whatever it is, it could be certified judgments, but you're starting to look at if that person is deceased, if that person is incompetent, if we have to get a guardian ad litem, if we have to start getting a newspaper, it could be 4 months. It could be 5 months. It could be 7 months. Who knows? It depends on making sure you have all the I's dotted and the T's crossed. So if you're looking for fast, it may not be good. But if you're looking for correct and right, then it could take some time. It's not like a 2 to 4 day special like probate sometimes. So do you have to quiet the title? No, you do not. You do not have to quiet the title. If you didn't want to do it and you just wanted to hold on to it for 4 years, you can, or the 1 year thing. But if you did want to sell it, if you get that tax deed on October 14th or wherever they're doing it, if you get that tax deed and then you want to flip it a year later, this is what you do have to do. Like the title insurance is going to tell you that there's no way you're getting around it. Great. I did put it here. Okay. Orange County. So I saw something really weird doing some research on tax deeds about a year ago. I think it was it was either before or after the presentation I did at Jax RIA on tax certificates and tax deeds. They had like almost like a disclaimer, a warning, and something that probably would be helpful for you all is when you're bidding on these, make sure you know what you're bidding on. It could be wetlands. It could be next to a refinery. It could be like a little strip, like in the back, I mean, what use is that for? Unless you want to put a trailer back there, but who knows? Everybody's got a different purpose. But knowing what you're buying is going to be really important. And Orange County really called it out. And they said some people were bidding, they win the bid, they get the property, and all of a sudden they find out it's like a little speck in the middle of somewhere, and it was like wetland protected. You can't build on it, you can't do anything, and you just paid a bunch of money for that. So making sure you know what you're buying is important. And what a shocker. I always talk about the title commitment. Always, always, always. So important that, especially if you're going to quiet the title, you want to know what the underwriter is going to want in a quiet title lawsuit to make sure that if you get the final judgment, if we get everything done, what are they going to want? What are they going to see? They want all these people served. They're done. So title commitments are a major part of my requirement. You don't have to get them, but I like to see them so we make sure we know what it's going to take to close or for the buyer to get a title insurance policy.